share those details. I let you guys know previously, we hope that you're all available today of the 19th, that you clear that day, so you're free. And we're going to practice here first. It's comfortable with their pictures that you can see me at stage, all the good stuff, so you can practice. I have a little bit of an audience. The questions off at that point, the decisions already been made. We're just practicing on how to pitch in front of the audience again. And we will go from there. And please, are you telling your friends and family to come up? You do so. And that's the housekeeping stuff that I have for this evening, but you all came for the main event. I'd like to introduce the resource in our entrepreneurial community. Not only because Derrick is curious and inquisitive about what you're doing with entrepreneurs, but he is a expert in helping tech companies to solve, and plan for the future and solve the problems that come up in the legal field. So I'm going to turn it over here, and I think he's looking at this being more so a fireside chat.
So I'm sorry to do this to you, but we're all gonna come in, right? We're gonna get close. We're gonna be family, so we can move these tables, scoot them up. Turn the flies. I respect everything you're doing right now. I want you to know that. That's so funny. Boss moves only.
Yeah,
Boss moves only. I love it. So kind of to start, I wanted to know who you are, right? And then I'll give a spiel about myself. Start from the right, make our way to the left. Love it.
Our office is in the software new application there to give you workshop and businesses and work.
And you know what? You're my favorite person in the room because you're the only one in the room that's hired me so far. So get that going for you.
Alex, I'm your specialist. We are making sitting systems for children's disabilities using 3D printing, so making customizable but also more affordable. And many legal issues in schools.
Yeah. Consumer products are hard. Yeah.
Hi, I'm Meg Trey. We are running Lotus fertility insurance, so direct to consumer fertility insurance.
It's a kick-ass logo.
Yes.
I love your logo. I love your logo.
Yeah, I'm
Not really?
Yeah.
That's so funny.
I'm Callie. We're CEO. CEO.
Very cool. It's good to meet all of you. Happy to be here with you all. As Joyce said, my name is Derrick Maultsby. I'm a lawyer. I've been working in the startup entrepreneurship ecosystem since I started practicing. Which I started practicing 3 years ago, but I worked full time through law school. So I've been doing this for about 6 years. I have a national practice, so I represent companies that are idea stage all the way through. I have 4 clients right now raising their Series A, and I've had 3 of my clients get acquired. So I have a lot of different experience. I also represent enterprise technology companies, so think Microsoft, Databricks, Sony, a few others. So I have kind of really cool, larger enterprise experience that I'm able to leverage and lean on for some of my smaller clients as well. My practice is mostly focused in what I like to say is focused in transparency. So because I'm so young, when I started practicing, I asked why a lot because law firms don't make sense. And especially law firms that want to work with startups and support the entrepreneurship ecosystem, they make no sense at all, right? Because the idea of a billable rate The idea of you tell me what you need and then out comes a bill later on that you don't know how much it's going to cost. Like none of that made sense to me. If you give me a phone call, I'm going to charge you for it. That sounds so dumb because now you're not going to call me, right? Like you're going to go and make the dumb mistake. And so I tried to just strip down the practice of law and build it back up with the entrepreneur in mind. And I've been moderately successful at it. But I'm fortunate enough to work with, I think right now, 65 founding teams across the country. And I represent 10 VC firms. And then I also do some like private equity work to keep the lights on asset. So I am one of the people that I love this work. This is actually what I love to do the most. I spend most of my year just traveling the country, sitting with founders, giving my time, and trying to give away as much free legal education as I possibly can. So that being said, one of the things I learned very early on is it is dumb for me to sit here and tell you a bunch of stuff. I rather actually make it so that this is valuable for you. You ask what you need, and we can start from there. Because I could sit here and talk about formation or trademarks or like whatever, and it'd be a complete waste of time because you've already done that. You don't have questions about it, but you do have questions about certain things. And some stuff I'll tell you, you're going to ask me, I'm going to say it depends, or I'm going to say let's not get too deep into that in public, and let's maybe talk about that offline one-on-one. But for the most part, I'll be able to like give some general guidance and feedback. So pretty much anything that you have. I'm not a patent attorney, so the patent process, I'm dangerous. I understand the process. Do not understand any deep questions. I'm not afraid. I've done trademarks. I hate them. So I just outsource that to somebody on my team. But from like a corporate standpoint, I do it all. So I'm able to, and I've probably seen it all, unfortunately, which makes me sad because founder disputes are the thing that keep me up at night all the time. So yeah, I mean, I saw a hand. I love it. So let's get it started.
So we're conversations with potential investors, with potential partners, with potential people that are working at firms that might be connected, that are interested in working with us. There's just a lot of these. We have a basic NDA, but what are your thoughts around navigating that space when we're meeting with so many different parties, and we should definitely have it in place in the NDA.
Yeah, so I mean, rule one, never send an investor an NDA, right? I've seen startups actually like get blackballed because it shows it's stupid because it's like an access thing. It's like if you don't know, then you're gonna send it, right? But an investor can't sign an NDA because an NDA restricts them, and they look at so many pitch decks and they meet so many companies that they can never look like they maybe took your idea and then invested in a company that does something similar. Especially investors that are like in specific verticals, right? So like fertility, right? Like there are obviously best investment firms that just focus on certain products within that you would fit within. And so they're never going to like agree to anything like that. Their reputation is what stops them from ever saying anything about your pitch deck to anybody else, right? Because nobody's going to bring them deals if they are out there talking about your stuff, right? So you kind of have to trust a little bit, which sounds, uncomfortable. But I always find it funny because like people who have like, a business lawyer that they're like family friend knew or something like that, they'll like send an investor an NDA and like a good investor will explain what I just explained to you and like work with you. But the majority of investors are kind of, we're in a safe space dicks, and they will ignore you and then probably shame you on Twitter. So, or X or whatever you call it nowadays, which I see a lot. So that's first thing, right? Now, when you think about partners, so I think the first thing you want to do is like have your buckets, which you just did, right? So you have investors, you have partners, and then you sort of had like this third bucket that was like, I'm going to call customers more than anything, maybe. And, the different conversations are going to have different information that you're bringing to the table. A standard NDA is fine and should get it across. I usually tell people that like for an intro conversation, you probably shouldn't be giving away enough that an NDA is even necessary. You know, so like there's also like a level of understanding your company and understanding what your secret sauce is to the point you actually never put it in there. And like that's the art of creating a pitch deck, right? Like your pitch deck doesn't tell people your secret sauce. Your pitch deck, you know, says the who, what, when, the why, and all that kind of stuff, but it doesn't give away everything, you know? Usually an NDA I think is necessary when you're gonna like dig pretty deep. Or like a service provider that needs to know exactly what you're building or exactly what you're doing to like be able to say if they can provide the service and like what the cost is and everything like that. So more than anything, it's like just truly figuring out the bucket what that person sends and like what information you want to bring to the table for that. And then the devil's really in the details of your partnership agreement, your customer agreement, and then you know the investment docs is a whole other conversation. Because the confidentiality, the IP assignments, those things are going to be like really important when you go to work with this customer, work with your partner long term.
Thank you.
Yeah. Hello. Also, hello. So we all introduced ourselves. Would love for you to as well.
That's using AI and the technology and variables for process erosion and also for creating return to use.
Very cool. Awesome. Thank you. I'm a lawyer. I work with startups. That's the Clip Notes version of it. And the way I like to drive these is allowing y'all to drive the conversation. So really just the questions that you have, the topics that you want to talk about, letting y'all drive that and letting me kind of respond. I can go into some canned stuff if nobody raises their hand, but that's going to be really boring. It's me talking at you for the next 45 minutes. Sounds terrible. I don't want to do it. You don't want me to do it. So if you have any questions, just toss them out there.
Medical device.
Yeah, a lot of it.
Or that's or not medical device. So we're making a ceiling system. If you're starting to get into the medical device field with all the FDA processes, regulations, etc., we will start to figure like high prices and hitting the wall together with other companies that can take this kind of FDA process. We're trying to see if we can market our product not as a medical device, but after seeking solution. Otherwise, also is provide you better seating, a better posture, and provide you the same benefits that not all device. Because also from the manufacturing standpoint, it's more complicated, but also from the insurance, etc., etc. So I'm trying to figure out how we can make the product fit. The goal is to make it as affordable as possible. And what I realized in other things is part of the pricing. So is it something that can be not as a medical device or channel?
Would you restate the question? It was a little frustrating.
Yeah, no worries. I think like the AC is so loud. So basically just asking specific question about the product they're developing and the classification of it as a medical device or not a medical device. That's it, just without having particulars of the situation. Sounds like the marketing of it would be important. I mean, you're already starting to talk like a lawyer a little bit, right? Which I appreciate. And I'd say like the application probably matters a little bit. I'd have to dig a little deeper into that, just into the facts. But I think there's definitely a route in which you don't classify it as a medical device. I mean, you're talking about seating and posture, and there's a ton of things I can go buy at Walmart right now that do very similar things, right? So like yeah, I think there's probably a road for you. Navigating that and really understanding from a marketing standpoint what you can and cannot say, right? Like that's something, so I had a client who was it's like a topical, right? It's like a CBD topical situation, right? And the CEO loved going to conferences and making statements about how this thing could like cure cancer and like all this wild stuff. Which like maybe, I don't know, but we didn't run the test on it, that's for sure, because we had decided that wasn't going to be, this type of product, right? She wanted to sell it in a e-commerce fashion with low regulation, everything like that. So we kind of like, we're going to follow like the CBD rules and guidelines and call it a day. But then she decided she wanted to go this route of marketing it very differently. And so what I would say is it's making sure that you understand the path you're going to follow, and then make the marketing, make the packaging, and all of that line up, right? I don't see that as being an obstacle that you can't get around from what I'm hearing right now. Maybe there's something that I don't fully understand, but I think you definitely can be able to go to market with that as a non-medical device that is, used for posture, whatever, right? So yeah, it sounds fine. The cost part of things though, that I don't know if that's probably up to like the manufacturing, right? And just seeing over time, especially as you start to bump up how many you make, right? How, what price per unit is, plus your marketing costs and all that kind of stuff, and wherever you can price point it that makes sense for you all. I know a lot of people try to go the medical device route for some of that stuff because the insurance pays for it. And like, that's the benefit of being a medical device. Then if you can get the insurance to pay for it, now I can charge whatever I really want. And so instead of charging $25 per unit, I'm going to charge $250 per unit, right? But like, it comes with a whole different level of issues.
This is all follow-up because there's definitely one round about the insurance pay, but most of the products making this route is so expensive that people that have no insurance, or in my case, children's will be covered by the insurance only each 5 years for one group. They are going in more than one group. So we're trying to make a line of products that will be affordable as much as possible for that. Marketing as a medical device, but then making almost the same product as medical device that goes to have the insurance. Would be almost the same as saying that this is not a medical device. The same, this is the medical device.
Yeah, I get what you're saying. Probably not a small alteration, right? It'd probably be like something significant. I think that's a problem that you would want to solve way down the line when you have a lot more money in your coffers to solve that problem, and like to develop almost a second tier product that could fall under a classification that's different. But I like the non-medical device route. I mean, medical devices cost an insane amount of money from a regulatory side, right? And it's so hard to get to that point.
The regulatory side, supply chain, because you have so many, and
Yeah.
So ensure that that's some kind of pricing. So everyone standardize the prices of the goods.
Yeah, and I mean, time wise, right? Like, so difficult. Like, just getting through that process takes forever. You know what I mean? Like, yeah. I think I like the path that y'all are on, and it sounds really cool. You said you're using 3D printing. Yeah, it sounds really cool. Plus, to your point, social good, having a product that is easily accessible, that is affordable, it's needed. You know what I mean? Again, there's a reason people go the insurance route and want to charge a ridiculous amount of money, but like, I don't know, if you can get to market faster with something that's actually accessible and affordable, that's awesome. Yeah, sure. Anything?
I was, gonna ask something that your follow-on sort of answered that.
Okay.
Yeah, I guess an additional question that is kind of related, and it is sort of specialized, so we not know, so we're actually trying, we've been similarly going back and forth about that stuff. And it's been, I can talk to you later about it, but, one thing that has actually been challenging to figure out is, what organizational and other types of larger entities know we purchaser if it's an place. And I know that we do that, but finding the information about that has been really challenging, which seems weird. It seems like it should be built, but it's not, and that's been a challenge. Do you even know if there are any ways to sort of find out what types of entities will cover certain things, if it's not in that box?
Yeah, that is actually a really hard thing to find out. I agree. I think the only people I know that like gone that route, right, and have found those people, like they just like meet people at trade shows. Typically, has been something that I found has been successful for a lot of people. So maybe even just looking into the the listservs and the sponsors and attendees of trade shows that fit your vertical could make a lot of sense. And then looking into like the specific thesis, or even trying to like, I mean, I'm a huge fan of cold calls. Like if you could find a few companies that you think might just cold calling somebody and asking, you'd be surprised where that could take you. You know, shot in the dark, never hurt anybody. Shoot your shot, as they say, right? So I don't know, that could be I think that could be a way to go. But yeah, like there's so much information that's just not readily available. And I hate to say it, but like a lot of it is just network and politics, right? Which sucks. But a lot of the buyers that have power to buy outside of insurance, like they go to the trade shows, right? So typically that's where they find the products that they want to support or cover or whatever, and that's where you make most of those contacts. But I mean, even just calling, you know, some of the companies, I think would be a valuable thing. Just asking, because they more so even know like, oh, we don't, but you know, X, Y, and Z does, right? And like hospital systems are probably like not a bad like place to cold call or look and asking like that question, because you know those folks know as well when they are, you know, advising somebody like on which way they're going to go. But I don't know of any resource that would just readily have that listed out. Probably doesn't exist. Maybe that is an idea for somebody to create something like that. But I don't know where it would be. Yeah, of course. Okay. Nobody has any questions? I'm gonna start asking you. I was gonna say I'm gonna start asking you guys questions.
Oh,
But I want your question first.
we are very early stage of bootstrapping,
Love it.
applying for grants,
Alrighty.
of course being one of them, targeting a raise probably April, May of verification of portable things like that going through. So that said, we're interviewing a lot of different lawyers right now, and it's like, we'd love to talk to you, by the way.
Love it.
What I'm having trouble wrapping my head around is we will meet with people who are kind of like, they run their own sort of firm, like they're a solo person, or we talk like the smaller boutique firms as well, and the larger ones also. I think what I'm having trouble wrapping my head around is like our needs as a company, especially as an insurance company, are going to increase as we grow. Like people will inevitably take us to court because they take insurance companies to court, right? So I guess like your perspective on, and which is also kind of why, well, do we partner with like a big firm that has the capability of doing that early on? Because, you know, we want to, like the relationship is the most important thing, and that trust and building that, and wanting something long term, but also recognizing that, you know, there might be stages or phases in our company in which like our legal needs will change and we outgrow a certain relationship. Or I'm curious about your perspective on that.
Yeah. It's a really good question. It's very insightful. Okay, so two-part. Maybe two-part. two-part stuff. So part one is, I think, go with who makes you feel comfortable, right? Because it is a relationship, you know what I mean? And like, I have clients that nothing went wrong, but like, we just didn't vibe, you know what I mean? Like, sometimes you just need to vibe a little bit, you know what I mean? Like, some of my clients are some of my best friends. Like, I love them. Like, I've been to baby showers, been to weddings, I've been to birthday parties. Like, yeah, like I've been at everything. They've been at every me. You know what I mean? So like, I think the trust in like that relationship, it matters. It's like the first date sometimes. Like, if you're sitting there and you're just like, oh man, I can't communicate with this person, and how's it gonna work, right? Like, I think that for relationships, for personal relationships, for professional relationships too, right? Like, having a lawyer that you don't feel comfortable talking to is probably a recipe for disaster. You're not going to want to talk to that person. And I think you should be able to have a conversation with your lawyer that's more than about just your business, right?
Yeah.
And, you know, don't get me wrong, some people love just talking about work, and like, I respect founders that do like just talk about work. But at the same time, like, I want to know who you are as a person. Like, that's a part of any relationship, especially a long-term relationship, which all of you generally are probably looking for at the beginning of your company. So I think that's really important. Trust your gut, right?
Yeah.
You know, you know if the vibes are there or not. Part two, I struggle. I know a lot of people that are like in the boutique route. I am not, right? I work for a massive law firm, and it's tough because it really just depends on who you're talking to and what firm they're at. I get a lot of people that leave certain firms to come to me, and I will tell you that in private, which ones. But like, there are firms that they're in the venture space because it's a volume game for them. We're going to bring in 100 clients this year. We're going to defer their fees and give them some package deal that's too good to be true, because it is. We're going to treat them like shit. I'm sorry, I swear. Shit. And if it doesn't work out, they'll get stuck with some $50,000, $100,000 bill, and we'll have our admin people hammer them for the next 5 years until they pay it. If it does work out, well, then we start charging them full freight anyway because they're successful. And so, you know, there's like that weird thing, and like the person who brings you in maybe answers your emails in 3 days or whatever, right? So like, and that's like the stories that you hear from the founders, right? That they go to some of these big places and get treated like crap. To your point, go to a small place, maybe it's a little bit more personalized, and we know the person, they're a little bit more responsive. But to your point, as your needs start to increase, and you need employment, and you need litigation, and you need patents, and you need, and the list goes on and on, are they the place that can support you? So now all of a sudden, you have, they're referring you to people, but now you have 4 law firms that you're working with instead of just one, right? And so, like, my battle, like every single conference I go to, without a doubt, right? Like, I'm going to a conference next week, and I know for a fact somebody's gonna go, man, why don't you just go out on your own, man? Because I don't want to, because that sounds like a lot of work, and I don't want to do that. You know what I mean? And it's also, my clients wouldn't be best served, right? Right now, I have 35 different lawyers working on various different things for all of my clients, right? I have a client, a hedge fund that's under SEC investigation. I don't do SEC work, but somebody in my firm does, right? So I was able to easily, as that thing happens to them, pull them in. Employment, immigration, various litigation, like all of those things. And then like also a full 35-person patent department for every niche thing that could possibly need a filing of a patent. And so for me, it's like, how do I best serve the client? And I think you best serve the client in the entrepreneurial space by, for me, I act as a boutique lawyer, right? It's personalized. It's not one size fits all. And like I said, kind of my little spiel, right? It's all focused on transparency, trying to take away the billable rate, telling you how much things are going to cost, giving you budgets, putting hard caps on things, right? And I mean, or you kind of, I guess we've worked together a little bit, so you can speak to it, right? It's giving that boutique feel, but at the same time, having the backing of a 750-person law firm with, 48 different practice areas, and knowing that as you grow, I have the capability to pull on people. If you work with a smaller place and you do need stuff, well, all their other clients need stuff too. And so now it becomes a capacity issue, right? And I am in a very fortunate position where I've been given the leverage to not have to bill people like I work at a big law firm, but also have all the resources of a big law firm. And it's been really nice, right? There's only a few places in the country like that. And everything's different for everybody, and everybody looks for different things. I have founder friends that use other law firms, and they use the other law firm because in their mind, using the biggest, fanciest law firm is what's going to make them successful. And I tell them all the time, whenever you need something, I'm here for you. Do what you got to do. You know what I mean? But and then there's people that want to use the solo person who's, down in Lawrenceville or whatever. And, they like that, right? And so it's different flavor for everybody. That's why I think part one, go through gut, is the best, because ultimately, you're going to, I think wherever you feel most comfortable is where you're going to have the best relationship, and where you're going to have the best relationship, where you're going to have the best experience. And then there is a third part. Part three is remember that no matter who you hire, you are the master of the relationship, right? I have so many founders, they're afraid of the lawyers they work with in this weird way. And I'm like, why are you afraid? You're the one that pays them. You're the one that can fire them. You're the one that hired them. I've never had a client email me, text me, or call me and thought to myself, I'm going to talk down to my client. If you're in an experience like that, then it's the wrong experience, and you can always fire your lawyer. No matter what, you can fire your lawyer. Maybe you have to think about okay, I'm going to fire them, but I owe them this money or something like that. That's usually where the tension lies. They overbilled you, you're unhappy, you fire them, go to a new lawyer, you owe them all this money, they keep calling you, and it's a whole thing. But even then, lawyers don't sue their clients. It takes a lot of money for us to want to sue a client, a lot. So if it's not six figures, more than likely you can tell them even hey, I'm firing you and I'm going to pay you back over the next 12 months. They just want their money. And so a little insider baseball, tell them how you want to pay them on your terms, and they'll be cool with it, right? But hopefully you never get to that point where you're in that kind of situation. But you're the master of the relationship. You're the client, and the client. I don't think the client's always right, but at the end of the day, it's your world. You decide who lives in it. So yeah.
Slavers. How powerful they are against lawsuits. Even example for the one-to-lunch early development. Maybe explaining to the customer there. Yeah, so I'm asking about disclaimers.
Maybe pass the mic around to them. Yeah. That AC is working against us.
So I'm asking about disclaimers. So if you want to start some early product and want to be covered, if something free or even in many cases it's not free, it's not manufacturing fault, but they use it in the wrong way or developing something unhealthy of the posture to the city. They share it speed or they use it in the wrong way. So maybe disclaimers is enough or it still will be open door.
Yeah. So unfortunately for all of us, we live in the United States of America, the most litigious country in the world, in which nothing will stop you from getting sued, right? And so, you sometimes forget that you went to law school and that you just know things. So you think the world knows all these things, right? I had the most painstaking conversation with one of my clients 3 months ago, in which they could not understand how that somebody could not pay them and they have to still perform under the contract. And I was like, well, yeah, they breached the contract, so we either have to sue or we have to keep performing, because if we breach the contract, then they're right and they're breached, and this whole thing, right? And I was sitting there and I realized contract formation basics are not common knowledge, right? And one other thing that's not common knowledge that I've come to find is no matter what you do, you can still get sued, right? I could sue you tomorrow for no reason at all, and you still have to pay money to answer the complaint and go through the process somewhat of litigation, right? And so with consumer products, there are like different levels of like risk, right? Like there's like inherently dangerous products. There's products that maybe shouldn't be dangerous. And then there's different levels of product liability. And it's like this whole thing. And like, I'm not really gonna, like, it's literally like a bar exam question. That all being said, a disclaimer is a piece of that is a mitigating factor, right? There's still, you still end up going to court and you still end up going through like a discovery phase where the fact finder eventually at trial, right, whether it's a jury trial or a bench trial, is going to have to be the one to decide, you know, whether whatever negligence or whatever happened with this product, you know, was a disclaimer and were your instructions and were all these things enough and it was actually the user error, right? Unfortunately, most of the time when you end up in court in the product liability case, you're gonna pay something, right? Like it just kind of is what it is. And to be honest, I'm a big let's just settle kind of guy, but I'm also a contract lawyer, so that probably says why. Like nobody wants to go to trial, nobody wants to waste that time. So a disclaimer, you know, instructions, you know, other things like that are really important. Beyond what's important is like talked about like, oh, like it was a manufacturing issue, not our issue. Well, what was in your manufacturing agreement? And did we cover, which we should, you know, indemnifying me for your mistakes, right? And so indemnification for the group, well, another thing, same words, I don't even know what I'm saying. Indemnification is a provision in a contract that basically says that if the party you're contracting with, if you're sued because of their actions in some way, they will either stand in your place in a legal sense if you're still there, but like they're paying for all of it, or they'll like reimburse you on the back end, right? And that's an important thing because if you get sued because of a manufacturing defect, the first thing you're going to do is notify them of the suit, and whatever the indemnification provision says, we're going to follow that process. And they're either going to pay for your legal fees or they're going to, you know, somewhat stand in your place and provide. Typically, it's pay for your legal fees because you want to use your own counsel and pick who's going to do it for you. But like, that's a really important thing, right? And so a big issue you see a lot of times is like early consumer products. They don't necessarily always have the strongest contracts in place with their providers, right? And then you end up in issues where like, okay, your manufacturer or your formulator or whatever, you know, whatever service provider ends up being a part of your product, they didn't do the right things and you end up in a bad spot, right? And you don't have an indemnification provision maybe or whatever, and you know, you're paying out of pocket for a mistake they made potentially, right? Or you're trying to sue them under some common law principle and trying to pull them into the lawsuit or something like that, right? So like it's complicated. Litigation sucks. It is how every law firm downtown exists.
Yeah.
It just is what it is. But my job, literally, I say like my job is just to mitigate that risk as much as possible and try to save you the money on the front end. Because it always costs less up front than it will when things go wrong.
So to be covered and like the product liability and lawyer backup, or it's.
You're saying product like insurance?
Yeah.
So you should definitely have product liability insurance. Yeah, absolutely. You probably should have also like a general business like liability insurance, right? And then yeah, like so when you get sued, your insurer has like a list of suggested counsel. If you have like a law firm you work with, like on your corporate side, and you want to like use them, you can ask your insurance company, like, hey, can we use our law firm? Like, you know, and then it's just a matter of like matching rates and stuff like that. But yeah, like you should definitely have those insurance policies because you're going to use them. Like if you're a consumer product, you're going to use it 100%, without doubt. It's going to happen one way or another, and probably a lot. But like, it is what it is, right? Like, at least you're not selling tractors. My old firm represented John Deere, and that was bad. Like, you know, you you can build an empire representing John Deere's tractor product liability cases. It's constant, every day. Somebody chops something off somehow. And they have a lot of disclaimers on those tractors, a ton. So, yeah. But like the hard part about like those questions is like everybody's like heard of like that hot coffee case, right? It's like, oh, if I spill coffee on myself, I can sue you. And it's like, it is that kind of true. That woman, unfortunately, like that's a bad example because like the coffee was like scalding hot and was very bad, and she like had she had a skin graft, you know what I mean? So it was like it was actually like negligence on behalf of McDonald's. But it's like a good example in the sense of like, yes, like minor inconveniences in life people sue over every day, and it's kind of why. I'm gonna start asking you guys some questions, right? Because this is I like poking holes in people's lives. So everybody here has their company formed, right? Formed. Okay. All LLC, C Corps, LLC, C Corp, and I knew that. Yeah, you're gonna raise some money. Yeah.
Same here.
Yeah. Yeah. You guys are intriguing though, because you're like an insurance company, but also a tech company, and it's just like, I don't know, that's a fun one. You're gonna need to be a C Corp if you raise money, but like, yeah, like, yeah, okay. So, does anybody know why you have to be a C Corp when you raise money?
Taxes.
Does anybody know why you have to be a Delaware C Corp when you raise money? That is one of the answers.
So investors.
So taxes was a part of it. So if you're a VC firm and you make, I don't know, 1,000 investments over a 10-year period, right? And you, for your books, you want to know that everybody across your portfolio is the exact same, right? It makes it easy. And so at some point, because Delaware has like the most sophisticated corporate, legal system, and the judges, like there's this opinion they put out about like a Series A financing that's incomprehensible, that no judge in Allegheny County would even be able to read and tell you what it says. Like they're just really, really good at what they do. And so at some point we all decided Delaware, and now everybody's stuck with Delaware. And that's kind of really the answer, right? Because like the difference from a tax standpoint between a PA C Corp and a Delaware C Corp is very minimal. The big thing is that there's having a standard across the board, right? From a practical standpoint, makes their lives easier. It's kind of just what it is. And you'll find that when you're like pre-seed or seed, people that are willing to invest in you, and you're still like something else, right? But if you get to that Series A level, you're just going to hit a wall. Because no institutional investors really go outside of that, and that just is what it is. The longer you wait to convert, the harder it is. Because when I convert, so I do 30 conversions a year. So you guys, like, converting is like the easiest thing in the world. It takes 5 seconds. But it gets more difficult if you wait longer and you take on investment from people prior to converting. Because if you're an LLC and you take on, like, let's say you sign a safe note as an LLC, which is wild because I've seen this before. In safe notes, people take a YC safe note and they enter into it as an LLC. Do you know what a YC safe note says? It says common stock and shares and all this stuff that are not applicable to an LLC. And so it just kind of blows my mind when people do that, but a lot of people do that. But when you have people on your cap table, when you're an LLC, you have to transfer over all the rights they had as a member of an LLC into being a common stock shareholder, right? And so the verbiage is different. The general rights are kind of different. So you have to look at an operating agreement and then make everything that they had in the operating agreement kind of say that in a stockholder agreement. It's wildly annoying, and it makes my life really, really hard. I did it once, and now I give it to some junior associate because I'm never going to do it again, but it's very difficult and very hard. It's just a tedious task. And so the earlier you can do it, when like it's just 2 co-founders or just 1 founder, whatever, it's simple because you just start fresh, right? You just convert, start fresh, wipe your hands of the LLC, don't have to worry about that. It's like $800 in filings though, which is something to know. Like, see the file with the state you're incorporated in as a limited liability company, You have to file like a plan of conversion. Then you have to file with the state of Delaware, and all this kind of stuff, right? So it's expensive from a filing standpoint. It can be cheaper if you don't expedite anything, but if you don't expedite because of the pandemic, folks are like, you'll wait like a month to hear something back from the state, maybe even longer. Whereas if you like a 24-hour expedite, it's a lot easier because it actually happens in like 2 to 3 days if you 24-hour it. So, and like the cost difference is not that much to matter.
It's the 800 inclusive of like the hourly user by the sort of.
That is literally just your filing fees. Maybe it's 8, it's like 6, maybe it's 6. I looked at one today, and I'm having a hard time remembering what it costs, like filing fees wise. But it's pretty expensive. It was like $596. That might be right, I think. So it's around there. It's between $600 and $800. So it's a little expensive, but in the bigger scheme of things, like kind of minimal. Typically, the suite is like just all the documents, all the filing, and then all the new documents for your C corp, right, and like everything like that. It's like $2,500 plus filing fees flat on that. I'm pretty positive. It's like a week turnaround is where we're at right now with conversions, but that's just something to think about. Take some time.
I actually have 2 questions. One of them is, I'm wondering what your thoughts are on getting a new C corp and assigning IP to it versus transferring or transitioning an LLC to an LLC code. For us, one of the factors we're looking at is we started 6 years ago, and also that we have there was a founder breakup, and it's just long changes and things. It seems even easier to just start that fresh and transfer everything over, but at the same time, the transition, or I don't know the wording, transition part onto that Delaware support, it also just seems faster and easier, at least from what I've seen. So I was wondering if you had any thoughts on is it for sure much better to do it one versus another?
Fully fact dependent on the individual situation. So for instance, I find converting is easier if everybody's on the same page, there's not a lot of history, stuff like that. The issue that I find with starting new and doing an IP assignment is at times, because I always look at it and maybe it's a negative thing that I do, but I always look back at it when I'm on the VC side, right, and I'm running diligence on a company for one of my clients, what looks more complicated and what's going to ask big more questions. And so when I'm sitting on this side of the table and I'm looking and I go, okay, so they started the company in 2023. They had this IP assignment from this other company. Now I ask about the other company, and you tell me that, oh yeah, this was this other company. We had it for 6 years. And I go, okay, look what happened. And you're like, oh, well, there was a founder breakup. And I go, okay, well, can I see the separation agreement between you and that founder? And you're like, well, we don't have one. I'm like, okay, so what IP rights do they have? Were they a part of that assignment? And then it just goes into my report to my client about the potential risk and liability that's out there in terms of the IP rights that maybe somebody had via that company, right? And so it just depends on the specific situation. I have done it that way, where you just start something new, assign the IP over. And there's a few reasons that I've done that. But there are reasons that I also have not. The other reason too is when it comes to names and marks and stuff like that, there's some interesting things that happen there that some of our trademark lawyers and patent lawyers sometimes have said it's just easier to convert, because you do have to then go in and change the name. You're assigning the IP, but now you have to go in and change names and patents and all that stuff. So the cost can add up. So it can be simpler for some people. It can be more difficult. It could lead to questions that are harder to answer. So it all depends. But there's 2 ways to do it. I tend to err on the side of conversion, just because it's less paperwork, if I'm being quite honest. and less to think about. Because like when you do a new and you're assigning the IP, you just really have to think about that whole company and like all the things that could have maybe go wrong with that company either floating out there, or if like we dissolve that company, like what liabilities are there? And then there's like this whole argument, like if there are any liabilities out there and close the company when you sign the IP, or that like can somebody have like a suit against us saying that we were trying to hide something? I don't, there's just, it all depends on the past. But it's a potential opportunity, and for your specific situation, it might make sense. I would need to hear more for sure. I would need to hear more for sure to tell you definitively which way I would suggest strongly one way or the other. And it might be a toss up, personal preference. It costs about the same either way. It might actually cost more to do, because like depending on the IP assignment, it could cost a lot, right? Because like you don't want to like do like a 1-page IP assignment that's kind of like generalized. Like you want to be pretty detailed and specific, and then you want to dissolve the whole company as well to make sure that there's no loose ends. So, yeah, very cool.
When you say what version, it's from LC to
C Corp, correct? Yeah. Okay, so everybody here, that's company, that's exciting. Does everybody here have an agreement between themselves and their company? Yeah. What kind of? Okay, all right. So, yes, the operating agreement more so is an agreement between you and the other members, right? So when I say that you have an agreement between you and the company, what I mean is you have equity in your company. Is there something between you and your company that gave you your equity and said what you're giving in return for that equity? Does everybody have that? See, yeah, I got that. And so was it do you have an LLC or a C Corp? You have an LLC, and so then you have some type of equity purchase agreement or something like that, right? Okay, very cool. Did you have a vesting schedule? Okay, so the next major F up that folks make is they start their company as you would, typically like LegalZoom or whatever out there, or like, family friend that's a business lawyer. And they're like, okay, cool, yeah, like I have my equity, which is awesome. Except the folks in this very building, IW, when you try to go get investment from them, they're gonna be like, oh, you're fully vested in your shares? We can't invest in you. Because as an investor, right, put yourself on the other side of the table, do I want to invest in a company where the founder could decide tomorrow that they no longer want to do this and they own 80% of the company already? No, I don't want to invest in that. That sounds like a terrible idea, right? And because people have burned investors time and time again, that is like a death blow, right? I actually just had to do a revesting agreement for one of my clients because I gave them the agreement, I gave them the vesting schedule, and they decided to change it and give themselves more equity faster. And sure enough, like I said, an investor called them on it and said, no, you need to change your vesting schedule. You can't own 70% of your shares in the first 2 years. It has to be stretched over 4. And so what you'll see if you do try to go raise money, or if you have co-founders, right? Like the co-founder thing is like the biggest death blow, and I'll get to that second. But even as a solo founder, like you still should have an agreement between you and the company that says, and so for C Corp, like what it's called, you know this, it's an equity for services agreement. And so people sometimes will say, like an investor will be like, oh, do you have founder docs, right? And the founder docs are going to be like your equity agreement, and they're going to be your IP assignment, right? Those are like your 2 key documents. Everybody that is on the quote unquote team should have those things signed, and they should be in your data room because they're basically like the most important things for each person. Because if that person just stops working tomorrow, you need to be able to stop their vesting and stop them from getting any more shares of the company. And if that person leaves tomorrow, we need to make sure that like the IP assignment, the non-compete, confidentiality, all that stuff's there as well. So they don't go across the street to a competitor and or start their own thing and compete with you, right? And take all your secret sauce. The reason I say for co-founders is the number one thing that happens to kill a company is a co-founder dispute. It is easily the number one thing, and sometimes not even a co-founder dispute. Like you can have like a founder and like a more of like a key employee or key officer, like whatever. And without fail, I see it every day, but like it doesn't happen for everybody. But like happens a lot. A co-founder or key employee who has maybe 20% of the company, 15% of the company, whatever, as a life-changing event. So I think kids, death in family, changing circumstances with no employment, whatever, or they just decide they're not interested anymore. And they stop, for whatever reason, they stop doing what they said they were going to do. And the rest of the founders and the other founder is like working their tail off. And this other person's just sitting there dead cat on the cap table, right? So the thing that is really important and why a standard, so it's a 4-year vesting schedule with a 1-year cliff, right? It's like the standard thing in the tech ecosystem. And what that means is that from the date the person starts providing whatever service that they're going to provide, that date, 1 year from that date, they get 20 or 25% of their equity. Each month for the next 36 months, they get a pro rata of the remaining shares. And if they ever at any point stop providing the services in that 3 years or in the total 4-year period, you can stop their vesting. So they only vest up to what they got or what they did to that point, right? This is a key component because you don't want somebody to be full. Like if you have somebody who's fully vested sitting on your cap table, not doing anything at all, then you kind of get killed because especially if you're gonna raise money, it's now the folks that are gonna convert onto your cap table via those safe notes, those convertible notes, and then potentially even like a Series A, a Series A round, you're going to kind of be in a bad spot equity-wise.
Yeah.
Right? Like a terrible spot equity-wise. And that will turn also during diligence when they see that, they're going to ask about it and they're going to be like, oh, the heck is this? You know what I mean? So it's a terrible thing. It kills you. So outside of just like, cause I'm a big pride guy. Like I'm a principal person. And so like outside of the principle, the fact that somebody owns like part of my company and doesn't do anything for it, I'm messing up my money, and I don't care for that, right? So it's just a really key thing, and it's something that early on is super important to do, and then it's an important practice to make sure you do with every person that's getting equity for whatever service they're providing along the way. And then, like I said, there should always be always accompanying that document should be I call it proprietary rights agreement, but that's just an IP assignment. Should be an IP assignment, making sure that they're signing over any IP that they're ultimately going to be like helping develop or work on.
So with that agreement, which I didn't, and then starting is new aspect and that was that kind of
Service. I'd say service date. Like I always say service date. So like it's okay as a founder to like put it in place and backdate it. Like I did that for one of my clients today. She's been building the company for 1.5 years. She brought on a co-founder recently. The co-founder triggered her to come talk to me. We're talking and she goes, should I have these? And I was like, yes. And so we just dated them for when she started her service, which is fun, right? Like there's nothing wrong with that. The important part is that you're just vesting it the right way, right? Like if you build your company for 4 years and never raise a dime and you're fully vested and you're fully vested in like, I don't know, 60% of the shares, whatever, and a VC firm comes along and goes like, oh, you're fully vested, but they see that you did it the right way over a 4-year period, they're not going to be mad for that, right? It's more so people that like started their company 6 months ago and own 80% of their shares free and clear. And the longevity there, if you build your company for 4 years, you're probably pretty in on your company. You know what I mean? Whereas if you're here for a year, sometimes good, sometimes not. Yeah, it is what it is. So yeah.
Or either conversion or ratings for the folks that they agent going to get a super document I've seen like different perspectives, and so I don't like that they need to be best. So it sounds like from what you're saying, like if there is a conversion or a new company, you don't have to like invest, like the person who.
So this is one of those tricky parts I was talking about, as opposed to a conversion versus creating a new company and doing an IP assignment. So, and this is where questions start coming in, and like it gets like foggy. So this just actually happened. So there was a company, it was an LLC. There's 4 founders. 2 of the founders just decide one day, like, we hate you, we don't want to work with you anymore, and they just walk the other direction. The other 2 founders are like, weird, keep it moving. They end up creating the new company, doing an IP assignment over to the new company, and saying that their years of service in the old company went to their vesting, right? No, that was not how investors wanted to see that. And it also kind of messed them up too, because like they didn't have a separation agreement with any of the old people for the old company. The IP assignments were lackluster at best. And so like it created a bunch of problems. And so like I think when you create a new company and you say that your service via the old company counts towards your vest, that is really difficult to kind of justify in my mind. And I don't think a lot of folks will necessarily, they'll see this as a new venture. And they all say like, that was great that you were building that company and it didn't work out. This is a new company and you're on a new vesting schedule. Whereas if you convert, you're converting your vesting schedule over, right? Like you're just converting that over. And so you have continuity. And I know it seems stupid and very, 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 very like arbitrary to say like, oh, but isn't that the like exact same thing happening? Because it technically is, but like the one thing you're not doing is you're not creating a new entity. So there's the company that you were working on is continuing on as this C Corp, right? And so you don't have a shift or a change. Whereas like the old company's dead and all of its liabilities dead. And so with that dies your vesting, your equity. This is all new equity. This is all new development. This is all new company. And so that is where it can get foggy. I think some investors, once again, pre-seed, seed level, probably okay with it. Just when you get into higher levels of diligence, it just starts to get so nitpicky, and just having it look as clean as possible is like the preference. For me, I'm very conservative with my clients though. So like some people might be like, they're like, we'll figure it out when we get there. But like, I just rather make sure everything's clean and easy and simple, especially because there's acceleration clauses in your vesting schedule. And so like, if you are to like have a financing that's over a certain amount or a liquidation, so if you get acquired or like whatever, you accelerate anyway. So you end up getting all of your equity anyway. So it doesn't really matter in my mind. Like I sit on a vesting schedule for the next 80 years of my life. Like if the company sells, I get my money. So it doesn't matter. You know what I mean? Like for me, it's like whatever. But I also understand like the idea, like especially with co-founders wanting your equity. So just depends on the situation.
I wanted to ask kind of similar to that situation, but entering a new variable, like what if you want to have research, basically like your LLC, if we can research companies so that we could like funnel like grants and research through that, but we still want to transfer to the C Corp, how can we keep our LLC existing even though we're transferring to the C Corp?
It's a really complicated question.
Sorry.
I mean, yeah, for sure. So you wouldn't convert, you would start the C Corp, right? And then the LLC would continue to exist as the LLC. Any cooperation between the two would need to be documented as if they were just 2 separate entities. You have 2 separate bank accounts, all your books, agreements, everything different. And that's really key for tax purposes because the IRS is bad. Really key for like commingling of funds and all that kind of stuff, right? When it comes to like piercing the veil of corporate liability, one company gets sued, but is the other company really just this company too? Like you want to make sure everything's separate. So whatever benefit you would get from the LLC for the C Corp, you would need to have like a research agreement, right, in place between those 2 entities that show, hey, like they're a service provider of ours. We just so happen to also own them. In which like, you know, like that all just needs to be papered appropriately. But there's nothing wrong with that. I mean, that is a model that I think a lot of people do here in the United States. So yeah.
Thank you.
Yeah. Okay, so we tackled some formation stuff, tackled some equity stuff. What time? It's 6:50. Okay, so we're almost done. I think it's a good place to wrap, to be honest. This was fun, exciting. Nobody else, if you ever have any questions, like Joyce said, I am a resource for the community. I really love to talk with founders and make time for folks. Art will tell you, I mean, you know, we probably touched base multiple times over the last year and a half.
So,
Yeah, I'm just happy to be here for the community, and you know, there's my whole thing. I'm not here to get rich off this community. Like I love supporting the founders. I love supporting your work. I'm not a creative person, so getting to support creative people is a lot of fun. And you know, if there's anything I can do for any of you, especially like when it comes to like connections to capital and things like that, like I'm very fortunate to get to meet a lot of cool people and do a lot of cool things, and so I'm always happy to put other people in positions to raise money and get the right things that they need. So I don't know, Joyce, did you share my information? Please share my information. You can hit me up on LinkedIn. You can follow me on Twitter. And that's it. That's all I have. Thank you all.
Deborah Walker had posed questions to some of you, and some might have raised some new questions from you. So Deborah was helpful. She kind of created a cheat sheet, like, oh, Derrick's gonna be here, have to talk about these things. So I hope we covered them.
I think we covered a decent amount of what it was sheet. Yeah.
Really well. So thank you, Derrick, as always.
Yeah, Deborah's great, by the way. I sit on the other side of her quite often.
But and just so you know, when she's asking questions, when she's probing, it's for your benefit.
And it's a great test run, because like that is like a baby diligence, right? Like this now is killing me inside. Like,
Is it because like from the beginning, they just have to go back and like, I think that they
this is like a client that was like using like a boutique lawyer first, and then a big lawyer second, and then me. And so like, it's like we had like she's literally in her email looking from 2017, like trying to find documents and like all this stuff. And like, it's just like one of those things. It's like, it's reassuring to know when I'm being like ultra high uptight with some of my clients. Like now I feel very good about it, because you're setting them up for the success, right? Like making sure everything's signed is another big thing, by the way. You'd be shocked how many people go like, oh, I guess I never did get that signed. I swear, like
No, I'm just saying it.
paid for the documents, look at them, everything, and then just like never get them fully executed, right? Like it's just insane. It's like little things, you know, it's insane though. And so like even just good hygiene things, like keep your data room ready, right? Like have it ready.
Data room.
So
Like a file.
yeah, so it could be a file. Like a lot of people use like a Google Drive. It could be whatever. There's tons of stuff out there. Carta is a tool that's super helpful. And basically, you know, you just want to have like all of your stuff just uploaded there, to make sure that like when it does get to like the day for somebody to go in there, it's all there, right?
Yeah.
And so like over time, you're building that room. And some people do it better than others. Like sometimes it's just a drive and there's just files. You know, trying to like put like legal, HR, IPS, like, you know, just having it all there, you know, vendor agreements, like, and really having it out and making sure it's all there. It's like, it's easy to do along the way. Very, 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 very hard to do 5 years into the future. And I speak from personal experience. But yeah, good talking with you all.
Thank you so much.
So, we want to take some leftovers, home and do some to-go containers. We're grateful to not be left with all of them.
Thank you. It was so good.